attention now to Florida, where the penalty phase for convicted killer Wade Wilson is underway. A jury found Wilson guilty earlier this month of the 2019 murders of Diane Ruiz and Christine Melton. And that same jury is back because they are now tasked with whether or not to recommend life in prison or the death penalty for the convicted killer. Now, before we get you into court, let's take a listen to some of the highlights from the opening statements that started earlier today, first by the state and then defense.
He waited. What did he tell his father? He waited for her to fall asleep. And then what wound up happening? Well, he waited because he told detectives he doesn't get scratched, doesn't get hurt, quiet, they don't yell, they don't get away. He's too strong. What does he do then? He goes ahead and inflicts blunt force trauma upon Miss Christine Melton. And then he goes ahead and places his hands around her throat, applies pressure until she is dead. You remember the broken nails? Ladies and gentlemen, the long, drawn-out nature and circumstances surrounding Miss Christine Melton's death is cold, calculated, and premeditated. He selected her, he secluded her, he strangled her. Cold, calculated, premeditated. And then we learn about the hemorrhage to the back of her neck, right? Ladies and gentlemen, we learned that the struggle was so intense that Dr. Coyne said, when we looked at the autopsies of both women from the internal and the external examination, he learned, and now you, that their struggle for the last moments of their life was intense. And we know that he showed indifference.
You might be a little bit, confused wouldn't be the right word, because as you sit here, you know there's only two possible penalties. One is life in prison, which means Mr. Wilson would go to prison for the rest of his life. Mr. Wilson will die in prison, or the death penalty, in which case Mr. Wilson will die in prison. Now, you're going to hear some mitigating circumstances, and we've already talked about this. We talked about it in jury selection. The reason they're called circumstances and not factors is because they don't have to be proven beyond every reasonable doubt. They only have to be proven to you by a greater weight of the evidence. We anticipate they're going to use terms like schizophrenic and bipolar, hallucination, adjustment disorders, suicidal, paranoia, delusional. They're going to tell you what those things mean. Then you're going to have to figure out whether or not Mr. Wilson's mental status rises to the level of your consideration to allow him to live. We're going to try and display to you what the thought processes were that were going through Mr. Wilson's head when these events occurred, why they were exacerbated by the consumption of controlled substances. This isn't an excuse for what happened. You've already decided that he killed these two women. We're not trying to excuse his conduct. We're trying to explain to you why somebody who's charming, polite, and cool would have done this. And it was something other than taking drugs that made it beyond Mr. Wilson's control.
It all comes down to aggravators and mitigators for this jury. The state showing those aggravating factors that prove that this was cold and calculated in nature, and the defense getting to bring in whatever evidence they can to try and mitigate things and convince this jury to spare this defendant's life.